Hello and welcome again to Immigration News and Views. My name is David Nachman. I'm one of the managing attorneys at the NPZ, Nachman Fulwani Zimochek Law Group. And what I'd like to do is let our viewers know, first of all, we have offices located in New Jersey, offices in New York. We also have an office in Indiana, and we have a presence in Boston and a presence also that we're in the process of developing up in Chicago, Illinois. And what I wanted to do today is to spend a little time talking to you about what the basic legal requirement is in order to file an H-1B. So before I do that, I'm going to tell you a little bit about the history of the H-1B. The history of the H-1B, at least when I first started practice back in 1988, was that we had an unlimited number of H-1Bs that were available. There was no cap on the H-1Bs. Now, as you all know, there's a 65,000 cap on a fiscal year basis. The fiscal year runs from September 30th to October 1st each year. And so during that fiscal year, there are only a certain amount of H-1Bs available. The reason why April 1st is the filing deadline, it's because you can do the LCA 6 months prior to the start date of the H-1B. So the way it works is that we file on April 1st, the April 1st filing date. We have the LCA, and what we do is we ask for an October 1st start date. So now, going back to the history, back in the early, late 80s, early 90s, there was no cap on the H-1B. And then what happened was in 1991, under IMACT 90, there was a cap that was placed on the H-1B. That was the 65,000 cap. And then what happened was, in order to keep people happy, because that cap was created, they also created several different classifications. For example, those classifications that were newly created under IMACT 90 were the O visas for extraordinary ability, and also O-1Bs for our artists, Ps for performing artists and athletes, and also individuals with cultural uniqueness, Q, the Disney visa, and R for religious worker visas. So all of those visas were created as a result of the cap, which was created. Now, there's also a 20,000 cap, and that cap is for individuals who have a master's degree. That 20,000 cap was later added when there was a big political uproar about the need for science, technology, and engineering mathematics specialists to be in the United States. Because what happened was, for many, many years, of course, we were training individuals, giving them a master's degree education, and then not allowing them to be able to stay here in the United States. There wasn't a pathway to allow them to stay. So by implementing the 20,000 cap for U.S. master's degree holders, it allows those individuals to stay here in the United States and to share their valuable skills with our workforce here. So we have this cap that was created back in 1991. It continues to be. The cap changed, by the way, as we approached the Y2K issue in 2000, and the cap actually went up, and then it went back down after 2000. I think it was around 2002, 2001, 2002, 2003. The cap went back down, but now we're at 65,000. So I just want to let everyone know that last year there were about 172,000 H-1B visas submitted, and again, there were only 85,000 available, 20,000 available for individuals who have a U.S. master's degree, and then there are 65,000 that are available for individuals who have the equivalence of a bachelor's degree. So what is that bachelor's degree equivalence that we talk about when we talk about an H-1? First of all, back before 1990, the legal definition for an H-1B was professional and specialty. It was distinguished merit and ability. So an individual was deemed to have distinguished merit and ability. That was what allowed them to have an H-1B. So distinguished merit and ability essentially meant that the individual had the equivalence of a U.S. baccalaureate degree. Under IMACT 90, when the cap was created and the LCA was implemented under the law, the definition was changed, and the definition became professional and specialty occupation worker. But it didn't really change the legal definition. In fact, the legal definition actually still exists for fashion models who do use the H-1B, where there isn't an educational requirement if you can demonstrate that the individual has distinguished merit and ability. But leaving that aside, so now what we have is we have professional and specialty occupations, and that is the definition. Again, professional and specialty occupation means that the individual has the equivalence of a U.S. baccalaureate degree. How do you prove that the individual has a U.S. baccalaureate degree? Well, of course, if an individual has a baccalaureate degree, then of course they have the equivalence of a baccalaureate degree, so that's easy. But what about people who have foreign degrees? So what we do is we usually work with our clients, usually the employees, sometimes it's the HR managers in the organizations that are doing the H-1Bs, to demonstrate that they have the equivalence of a U.S. baccalaureate degree. That entails our reaching out for a credentials evaluation service, and hopefully what we do is we get a credentials evaluation service that is a reputable one. And the reason why that's so important is because we're finding more and more RFEs, requests for evidence, coming back questioning sometimes this credentials evaluation that we submit. So there are two ways in which credentials evaluations can be done. One is you can do it based upon academic equivalency. So if you have a foreign degree and what you're doing is you're looking for an equivalency evaluation, it's based upon having the academic equivalency. However, and in some cases, you may have some academics and you may have some experience. In the federal regulations, there's something called the 3-to-1 rule. The 3-to-1 rule allows an individual to use 3 years of experience, professional level experience, to demonstrate that they have the ability to have, I guess, the equivalency of a baccalaureate degree. So 3 years of professional level experience is equal to 1 year of baccalaureate degree education. And so you could use the 3-to-1 rule. So if you have an individual, for example, who has 12 years of professional level experience, then that person has the equivalence of a U.S. baccalaureate degree. The key here, and what's really important, is to ensure that you use an academic credentials evaluation service that is reputable so as to be able to rebut any potential argument by the USCIS that the credentials evaluation, the underlying credentials evaluation, is either improper or has not been, doesn't hold water. So with that, we'll come back and we'll discuss some other issues that are related to the H-1B. But I want to thank you very much for being with us today, and bye for now.